Hello, how are you doing? You're welcome to Lawyers Infohub. You're welcome. It's always a pleasure to create content on this platform. I'm your host, Mercy. This platform is born out of love, passion to see to the growth of legal education in Nigeria, in Africa, and the world. We try to simplify legal concepts to help for ease of understanding. It's an academy. We are passionate about excellence in law practice, growth in legal practice. We want you to grow. We want you to learn in a more simplified way. So today we're looking at no case submission. No case submission. If you're yet to subscribe to the channel, please do hit the subscribe button, share the video, drop your questions by way of comments, and we will attend to it. So, what is a no case submission? Criminal trials or criminal proceedings is, for me, is a special one because uh, each step of the way it gets interesting. And as a lawyer who is involved in the criminal proceedings or a criminal trial, you must know what to do at every point in time, from the point of arraignment to the point of taking of plea, to the point of bail, to the point of the prosecution's, you know, proving his case, to the point of now no case submission, to the point of defense, to the point of trial, which is also their defense, to the point of final written address, to the point of judgment. So today we're looking at no case submission. After the prosecution must have finished his part, by bringing his own witnesses to testify, to prove, the claim or the charge, to prove that the accused is guilty of the charge. After they have closed their cases, now for the defense or the defendant, the accused person, to open or her defense. Now you can choose to do a no case submission or you can choose to open your case. But when you elect to do a submission of no case to answer or no case submission for short, which is what many people know it for, then we're going to discuss how it is done, what manner, how do we go about it, um, what happens when the court upholds your no case submission. You know, we look at issue of acquittal, under no case. Yeah. So we're going to look at section 286 of the Criminal Procedural Act. I'm going to read it. Say, if at the close of evidence in support of the case, it appears to the court that a case is not made out against the defendant. Now, section 286 of the Criminal Procedural Act is saying that where after the prosecution have closed this case and it appears to the court that a case has not been made out against the defendant or the accused person in the instance sufficiently to require him to make a defense, the court shall at that particular time discharge him. The court will discharge. Say where it appears to the court that at the close of the prosecution's case, that the prosecution has not made out a case against a defendant or an accused person, that the court will what discharge him. By section 36 sub 5 of the Constitution, um, under our Nigerian legal system and then our Nigerian criminal justice system, an accused person is presumed innocent until proven otherwise or the contrary is proven. So when an accused person is adjudged to be innocent, this person is still innocent until you prove otherwise. Now it now brings a heavy duty burden on the prosecution to prove that this person is guilty of the charges we have filed, and that contrary should be what proved of his innocence. So after the prosecution must have, closed this case, this is one option the defendant can take, or even the court, where the court is satisfied that, see, I'm not satisfied that you have been able the charge against the accused, I'm going to discharge him. Now the question is always, has a prima facie case been established? Has a prima facie case been established? Now, a submission of no case to answer or a no case submission, as we call it, It is only it may be made where there has been no evidence to prove an essential element in the alleged offense. If, for example, somebody has been charged for stealing, and at the end of the prosecution's case, the defendant counsel, you are saying, or even as a defendant, prosecution, you have not been able to prove the essential elements of this offense of stealing. Then we can bring in a submission of no case to answer, whereby the evidence that has been adduced by the prosecution has been discredited during cross-examination. The prosecution has called witnesses in proof of his claim, or in proof of his to prove the charge profiled, and during cross-examination, it was clear that all the evidence adduced by these witnesses has been discredited. It has shown that they are lying. It has been shown that it is doctored, or it has been shown that they were even saying what they did not witness. They are hearsay witnesses. These are examples. Or that their witness or the evidence is manifestly unreliable. So if you can show that the evidence is manifestly unreliable, it's been discredited during cross-examination. So you can bring up your submission of no case to answer. Now, under the ACJL, that's the Administration of Criminal Justice Law of Lagos State, or isn't that each state has their own modified it to suit in their own circumstance. But for the Administration of Criminal Justice Law of Lagos State, a 2011 law, it especially states how you can bring a no case submission. Now, by Section 239, sub 1 of that law, it states that if at the close of the evidence in support of the charge, that is, at the close of the evidence of the prosecution, it appears to the court that a case is not made out against the defendant. Earlier in this class, I've talked about the Criminal Procedural Act, what it states. So this is like a replication of that. So when it appears to the court that the case has not been made out against the defendant sufficiently to require him to make a defense, the court has discharged him in respect of that particular charge. Now, sub 2 of that section 239, said where this particular defendant is represented by a legal practitioner, he shall make what an application to invoke that subsection 1. So where a defendant is represented by counsel is obligated to make that application, to make that application for a no case submission by filing these or her processes, submitting to the court that no prima facie evidence have been able to be established, that the evidence adduced by the prosecution have not been even proved an essential element of the alleged offense, that the evidence adduced by the prosecution has been manifestly unreliable or discredited during cross-examination. Is very, very important that the prosecution has failed to prove an essential element of the first charge. This is very key because these are what will form part of your grounds upon which you're filing your no case submission, your affidavit, and your written address. That the evidence adduced by the prosecution has been so credited as a result of cross-examination, the evidence is manifestly unreliable, that no reasonable tribunal will convict on it. One of these two elements must be proved. Must be proved. Now you see, where a defendant have been, maybe there are 3 count charge and then the defendant, you can choose to make a no case submission for 1 or 2 of the grounds. Even if in hospital you have 4 grounds or 3 grounds, you can choose to make a no case submission for 1 or 2 of the grounds, or you can choose to make a no case submission for all the grounds. Now, what is the duty of the court? What would the court do where a defendant counsel have made a submission of no case to answer? When the court looks at the application, which obviously you know that the prosecution will what's counter by way of a counter affidavit to the motion or the application stating the otherwise, the court will make a ruling. The court will make a ruling. The court will make a ruling. And you see, this ruling of the court, this is where many people, raise the issues of error in law, where the court, some say it's supposed to be a short ruling, others are saying maybe the court has gone deeper than what was presented, and all of that. You see, the ruling of the court on a no case submission is like any other judgment of the court, and it has to be detailed and analyzed all issues for determination. So, because the defendant will bring in a submission of no case answer will bring out issues for determination based on the fact that the prosecution have not been able to prove the elements of the crime, the issue of being the prosecution with have been discredited during cross on the evidence manifestly unreliable. So the ruling of the court must also be what detailed. See, let's look at the Criminal Procedural Act Section 245. It says that the judge or magistrate shall record his judgment in writing, and every such judgment shall contain the points of determination, decision therein, the reason for the decision, and all of that. Just like a normal judgment, the ruling has to be concise. It has to state the analysis, the evaluation of those issues raised by the defendant counsel, and how the court was able to arrive at his ruling, at his decision, to say whether the no case is sustained or the no case is not sustained. At the point of no case, the court has not been able to hear the defendant. The defense has not opened this case. So the court is not obliged to express its opinion as to how credible the evidence presented by the prosecution is, as such evidence can still be rebutted by the accused person's witness. Because the court has only heard on one side, it has to be very careful on how it analyzes the evidence of the prosecution, because he has not even heard from the other part, who is a defendant. At that point of ruling, the court is only looking at it from one point. Court is only looking at it from one point. As much as many people have argued that it should not be a lengthy ruling, but I am of the view, and I know that is the law, that at least the ruling of that court should be able to have full evaluation based on the evidence produced or adduced by the prosecution. There should be a proper analysis of the case of the prosecution at that point. So the court can overrule a no case conviction. The court can also agree with the defendant to what? To agree that, see, the prosecution has not been able to provide a prima facie case. See, let's look at the case of Atano against AG of Benders. It's a very old case. It's a 1988 Nigerian Weekly Law Report, part 75201. In that case, at the close of the prosecution case, the judge made a very lengthy ruling dismissing the no case submission put up by the defense. The court thoroughly considered all the grounds on which the defense based its submission and reviewed them accordingly. The court subsequently called upon the accused persons to open their defense, after which they were convicted. You see, the accused persons appealed their conviction. Their contention in that appeal was that they were not given a fair trial as a result of the lengthy ruling of the court when it overruled their no case submission. But the Supreme Court held that the length of a ruling without more does not conclude that the judge has furthered his discretion in overruling a submission of no case to answer. That's what I'm trying to say, that the fact that the ruling of a court is lengthy, many lawyers are always, the ruling of the court was lengthy, it was not like a judgment. It has nothing to do with the evaluation of the evidence of the prosecution. So in that case, the Supreme Court said the length with that more does not mean that the court has fettered its discretion. So it's very, 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 very germane. It's very, 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 very germane. Now let's look at the effect of a discharge. When the court in its ruling and said, well, I agree with the defense. What is the effect of that discharge on a no case submission? Now, under the criminal procedure, you see, the effect of a ruling upholding a no case submission is that the accused person is discharged on the merit. So when the court believes what the defense is saying, that the prosecution have not been able to even establish a prima facie case against the accused, and the court discharges the defendant, that is the accused person, it is a discharge on the merits. So when is the discharging on the merit, the prosecution cannot go back again to come and rearrange that person on the same charge. No, no, it can't happen. It cannot happen. So it has to. It is. The effect is that it is a discharge on the merit. It is a discharge on the merit. So such a person under section 173 of the ACJL, let me read it. It said, without prejudice to section 162, a person charged with an offense shall not be tried if it is shown that he has been previously convicted or acquitted of the same offense by a competent court. He has been convicted or acquitted by a competent court on a charge on which he might have been convicted of the first charge. He has previously been convicted or acquitted by a competent court of an offense other than the offense charge, being an offense of which part, apart from this section, he might be convicted by virtue of being charged with the offense charge. It means, you see, many a times you see when a prosecution in favor of the defendant on a no case submission and he's discharged on the merit. See, sometimes the prosecution or the complainant might go up again, they start tramping up, trying to, okay, if he goes off for this, he can still be held for this. To come and put up charges again to rearrest and charge this same defendant and accused person in court. What the provision of that ACJL is saying is that for the fact this person has been discharged on this offense by the ruling of that court in a no case submission, you cannot come and rearrest and charge him to court again. So it has the effect of what discharging their defense on the merit. On the merit, like as if the court had in full. That's what it means, as if the court heard both sides. Remember, I told you that at the point of no case, the court has only heard the prosecution. The court has only heard the prosecution. So for a defendant, an accused person who has been discharged on the ruling of the court on his no case submission application, he cannot be retried again on those same charges. So, friends, I just hope you've been able to learn something today. Yes, on no case submission, what is all about, when you can bring it, the effect, what the ruling of the court should be, on the ruling of a no case. Now, sometimes people mistake issue of discharge and acquittal. An accused person who has been discharged, you know, look at, let's say, will not face a second trial for the first time. So acquittal, sometimes acquittal, when you say it has been discharged and acquitted, you hear that word a lot. He has been discharged and acquitted. It means he is free for all purposes for that particular offense. See, it is very similar. This word acquittal, discharge. Now, when you are discharged on the merits, you are discharged on the merits. Even if the court did not say acquitted, you cannot be tried again. Cannot be tried again on that same charges. So you see, under the ruling on a no case submission, the word is always discharged on the merit if the court aligns with it. But where I didn't know the whole trial, the court has heard from the prosecution, the court has heard from the defendant, and the court says the defendant stands what? Discharged and acquitted of all the, it also means this same person cannot be retried again on that same offense. So I think the difference is on the stages at which the court makes that declaration. Yes, so you must understand it for future reference and for understanding of what a no case submission is all about. But where the court refuses that application for no case, it's now for the defendant to open his defense. Call your witnesses, let the court know why you're saying you're not guilty. You understand? Why you're saying I'm going to be guilty for one count, I'm not guilty for the rest. Come and show bring up your defense. We have also seen instances where, after the court has ruled that the defendant is charged on the merits, the prosecution appeals. There are instances like that. There are instances like that. I've also seen instances where when the defendant is being overruled, they also appeal. So it's just a step. So a submission to no case to answer is a step in criminal trial. I just hope you've learned something today. Please do subscribe to the channel if you have not. Thank you for those who have subscribed. If you came back on the channel to know what is new, I really appreciate you so much. I really do. Thank you, my subscribers. Those who subscribe, I thank you. Watching me for the first time, I thank you. You're welcome. I just hope you learned something from this class today. Share to your friends, share to your colleagues, share to your mentors, share to your mentees, share to everyone. Yeah, knowledge is not a waste. Knowledge is light. Eradicates ignorance, which is darkness. Do take care of yourself and know that you can be the best wherever you are. Do take care.